Good evening, everyone. It's my pleasure to open now this um, exciting series on art, new technologies, and copyright. And new technologies means especially AI, artificial intelligence, and that is, my field. And I started with AI, I remember very well, 4 decades ago. That was in a time when it was not so popular as today. It was more in the tradition of formal logics. But nowadays, what is AI? AI is statistics, nothing else. It is optimization of big data with learning algorithms, detecting statistical correlations and calculation of expectation values of certain symbols, nothing else, but with amazing results. And that is only possible by this exciting computational power of our computers nowadays. Now, we are an academy of science and arts. And what does that has for consequences for arts? Now, nowadays, it is not only possible to reproduce and to generate new paintings or novels or things like that, but even actors in the movies can be replaced. And not only in Hollywood, but also here in Munich, we have the University of TV and Movies. They are excited and they are horrified by this possibility. So it needs copyright, not only for these kind of products, written products, things like that, by copyright for persons. I think very exciting aspect. And the other part means science. We are an European Academy of Science and Arts, and here we were very rapid. The European Academy of Science and Arts was very rapid. Some of you will remember it was in the end of 22, and ChatGPT came up. And rapidly, the European Academy of Science and Arts started with a commission, with a committee. It was organized by, initiated by Claudie Bochting. I remember very well. She is a physician and member of our academy. And it was an international European commission with the Institute of Advanced Studies in these European countries. And what did we write? We write living guidelines of generative AI. And that is this kind of AI which is the basis of ChatGPT and OpenAI and so on. And what did we consider? What will be the consequences concretely for working scientists? For example, the request, do you use in your article AI or ChatGPT? And last week, by the way, I had a peer-reviewed article for myself, and I was asked, do you use this kind of AI? That is now standard, but we came up with that, and in our committee, there were, by the way, people from Nature, this famous journal, and so our living guidelines were immediately published by Nature. And we did not only consider the consequences for the scientists, but also for the editor of journals. Johannes, you are an editor of a journal, our journal. And the question of selection of reviewers. In our case, that may be no problem. But if you consider, for example, chemical reviews, there are thousands of chemists involved. Nobody knows exactly who is a specialist for this highly specialized article. And so it needs this kind of automated selection procedures. But you must know, as a writer and a scientist, your reviewer is selected by such a kind of automated procedure, and perhaps even it may be possible you are evaluated by such a program. And these are exciting requests. It must be announced. Also, the producers must clarify their data in order to train. That is crucial in machine learning, to train these machines. And in the end, all that is now more or less standard. That's only 2 years ago, and we came up at first, I think, with this kind of requests in the academy. But we had a last request, and I think that will be interesting for this evening. We had a request, namely, there must be some kind of central institution, such as the World Health Organization. That means perhaps connected with United Nations, with UNESCO. And I think that is a question which could be also considered this evening, because we have speakers who are in connection with these organizations. And so I'm very eager to learn your ideas to continue in this tradition of our academy. Living guidelines. Why living guidelines? Because these guidelines must be changed. The progress in these technology is absolutely exciting and amazing. And so we must work on these requests. Thank you very much.
Excellent.
Thank you.
Thank you very much, Klaus.
Dear
So
Tassos, I can see that we have one of our participants is the president of the Blue Shield of Greece, Dr. Elena Korka here.
Yes.
Could you ask her, please, to greet the... She's here, yes.
She was trying to unmute.
Can you hear me?
Yes. Now we can hear you.
Hi, Helena.
I lost you too, but finally I'm connected again. I would like to say on the part of the Hellenic Committee of the Blue Shield that we're very proud to be an endorsing organization for this wonderful series of colloquia. Actually, I think it was such a prototype, an interesting idea, that it has found very many followers. For the people in the Hellenic Committee for the Blue Shield, these topics are very interesting. I know that Mrs. Stamatou, who is our vice chair, has helped a lot in proposing certain speakers, and we have also had people who connect to the Blue Shield, having even the president himself of the International Blue Shield, which is an organization connected to UNESCO and very important for times of crisis, especially conflict and war. I think that tonight we have wonderful speakers. It is a great privilege to be able to hear all the wonderful work that they have done for so many years. They're so prominent in their fields that, and it's a very specific topic. So I'm sure that we will learn very much. I hope that this series of colloquia can continue next year as well, with even more important issues at stake. And I think that we must congratulate the European Academy of Sciences and Arts for this very advanced let's say, decision to engage so many different people from many disciplines. And we have enjoyed and learned so much from the previous colloquia that I'm sure tonight will be very enlightening as well. Thank you.
Thank you, Elena.
Very good. Okay, I think now we are ready to start. I will simply announce that Professor Paul Torremans will be our first speaker, Professor of Intellectual Property Law. He is the co-director of the University of Nottingham Commercial Law Centre, Faculty of Social Sciences. And I would like to ask him to, it is interesting to read a few lines of his curriculum vitae. Professor Dr. Paul Torremans, he is a professor of intellectual property at the University of Nottingham. He holds degrees from the University of Leuven, KU Leuven, and the University of Leicester, and he has had appointments at the Universities of Leicester, Ghent, and Leeds. He is a vice president of the Association Littéraire et Artistique, I guess this is French, International, and a member of the Max Planck Conflict of Laws in Intellectual Property project. He recently worked with Capgemini in a project on centralized copyright opt-outs for the European Commission, and we're on a copyright buyouts project is now ongoing. He has consulted on copyright cases in Europe, very often in the US, and he regularly works on copyright with the WIPO Academy. Okay, Professor Torremans, you are welcome to start your presentation.
Okay, good evening, ladies and gentlemen. It's an honor and a pleasure to be with you. I trust you can see my slides.
Yes.
Let me start by saying that I think what we're doing this evening is let me focus on art and copyright, and then maybe start applying that to new technologies. And then Dr. Soos can continue more specifically in an AI context. I'm hoping that way we don't overlap too much. Now, if I can try and move the slides. There we go. What I would like to do as in the beginning is just to take you back to the good old Berne Convention on Copyright, 1886, because that is still the foundation on which we work. And if you look at Article 2, what you find is a very wide-ranging provision saying what we protect here in copyright, all the member states, and it's pretty much worldwide nowadays, what we protect are literary and artistic works. Now, they include every production in the literary, scientific, and artistic domain. I won't read you the whole provision, but there's plenty of things there. Now, what is important to note is that this is it. In other words, there are no definitions of, for example, what is a sculpture. The word sculpture is there. All these things are left to the member states. It's even worse, if you want, because this is an open-ended list. These are just examples. So member states have a freedom to add things and to decide for themselves. We'll come back to that. I think it's important to keep that in mind, because lots of people have the idea that there is an international basis and there are definitions of, for example, what is a work of art. Well, in practice, there is no such definition. Now, it is also important to note that at that stage, immediately afterwards, the Berne Convention moves on to the author. It is an author's right. Now, the way the convention looks at this is clearly with the idea, of course, we are in 1886, I know, but I mean, the concept is clearly that there is a natural person who is the author. that natural person and later on also gets moral rights. It's very difficult to see how moral rights can be held by a corporate entity, for example. That's a concept that doesn't really fly. Now, in terms of AI, if we move on to that topic for the first time, that creates a rather interesting proposition because people have tried to convince, for example, the US Copyright Office that an AI generated work is a work altered by AI. And for the time being, the Copyright Office has refused that. And for the time being, the US courts are agreeing with that. So that again asks interesting questions because if it is an author's right, you need a natural person. Now, the next question then is, well, what does that natural person need to do? If there is a combination of a work and an author, well, what is the contribution of the author? And then the question is, well, what if the machine does? If the AI does a number of these things, are we still talking of a copyright work? I mean, for example, if you generate loads and loads of images, novels, pictures, paintings, whatever, through AI, can you still enjoy, or can your AI, if you want to put it in that way, enjoy protection under copyright, or are we simply bypassing copyright at that stage? Which, of course, that means everyone is free to copy, everyone is free to communicate to the public. You get a very different business model at the end of this. Now, the other thing that I think is extremely important in this context of our topic for this evening is that the Berne Convention not only does not have a definition of what is art or what is a work of art, but clearly the way this thing works is by putting the emphasis on the person of the author. In other words, in that list of works that are protected by copyright, there is no quality judgment. I mean, we are not saying that in terms of a sculpture or in terms of a picture, a novel, or whatever, certain standards need to be met. The standards come in via the author. And that's where the concept of originality comes in. Surprisingly, the convention doesn't quite, well, the first doesn't define originality. It doesn't even talk about originality. It assumes that that comes in via the person of the author. Yet again, in terms of AI, where do we go with originality if it is the author's contribution rather than the AI's contribution? Now, if we look at originality,
let me ask you, excuse me, Professor Thomas, what are these bullets referring to? InfoPack, Painter, Convenel?
I'm coming to that.
Okay.
I'm coming to that. So, originality. You know, if that is the quality threshold, if that is the kind of standard that we need to see, and potentially the question later becomes, can we move away from the natural person? Can we say that originality can come from the AI? That's another question, but what is that originality? What is that threshold? Well, in terms of the jurisprudence from the Court of Justice of the European Union, what you find first is a case by the name of InfoPack. This was about work from journalists being put online, where the argument is, this is the author's own intellectual creation. So again, there is a very strong, the court makes a very strong link with the person of the author. And it has to be the author's contribution, the author's intellectual creation. Now that's interesting enough. And by the way, for the little footnote, it's also interesting to see that despite Brexit, the United Kingdom still hasn't changed that. I mean, this is not just the European Union. This is slightly wider, and the case has been followed, accepted in quite a number of countries. Now, later on, you get the Piner case, and in a sense, the fact that Professor Tefniak is not here makes it slightly easier for me. See, she was the Advocate General in the Piner case, so I can probably put it in a slightly bolder way without being corrected here. But for our purposes, what Piner says is that if you make your own intellectual creation, there has to be a free and creative choice by the author. So in a sense, the argument is this intellectual creation is based on the fact that the author has choices, creative choices, to do one thing or another, and you need to make a free choice. If a choice is dictated by other factors, that doesn't result in an original work at that stage. Now, Piner is an interesting case for our purposes because it's about photographs. It's about a rather dull photograph because Miss Piner was the photographer who took school pictures, amongst others, from Natasha Kampusch before she was kidnapped. The photograph was later, with permission, used by Austrian police to try and trace her, and they adapted that with aging software and so forth. The problem arises when she's freed. Of course, the police doesn't want immediately to put her in front of the journalist. On the other hand, the newspapers don't want to report on Natasha Kampusch has been found, she's free, without a picture. You need a picture. So illegally, one way or the other, these pictures from Miss Piner, the old school pictures with the aging software applied to them, have been leaked, if you want, sold. Well, I should not say leaked, because quite a lot of money was being paid. Right? They've been given to the newspapers. Miss Piner sues because I am the author, I have the copyright. Question is, what is originality? Because it's a school portrait. Well, the argument that is being developed is there are free and creative choices in there. Because as a photographer, you decide on the background. You can take a gray background, a white background. You decide on how you frame the picture. How much of a close-up do you make of the child? What kind of position do you give to the child? How do you arrange the light? What kind of filters eventually do you use? Do you use a filter to give a certain background or whatever? That's a free and creative choice. Now that becomes interesting later on if we talk to AI, because you need to try and apply that in an AI context. But let me come back to this kind of free and creative choice, this free choice, because in Europe we brush that under the carpet. Our American colleagues are much better in saying there is in copyright, there is an idea expression dichotomy. And in combination with that, there is a functionality exclusion. Very simply put, free and creative choices, the idea is to take a school picture. How you express that, how you do that, in making that expression, you make free and creative choices. So it is the expression that is protected by copyright. On the other hand, if it's a purely functional work, you don't get copyright, because then you don't have that free choice. In other words, there always needs to be more than one possible expression. Now, taking that a little bit further, you get cases like Lucasfilm and Ainsworth in the United Kingdom. Now, it's just a UK case. It went all the way to the Supreme Court, I know, but I mean, it's just a UK case. I'm not saying this is absolute gospel, this is what we should do. But the judge's first instance said there, this was a case about the Star Trooper helmets in the Star Wars movies. You have an English designer who eventually designs these Star Trooper helmets for the movies, and later on sells a few of these as souvenirs and then gets sued by George Lucas. The question is this a work of art? If this, in copyright terms in the UK, is this an artistic work? The act, the legislation, does not have a definition. Well, Mr. Justice Mann said in this case, there is no copyright. This is not, for copyright purposes, an artistic work. Because the main motivation for the way you expressed yourself, the way you shaped these helmets, were functional. They needed in the movie, for the characters, they needed to have a certain function. They needed to work in the movie. And on that basis, it's not an artistic work. Now, maybe that's a bit more of a radical approach than, for example, the Pioneer approach, because here the argument is primarily created on a functional basis. And I think that becomes interesting if we think of applications like 3D printing. You know, if the main, again, that's a choice of the member states. In the UK, the Court of Appeal agreed with him on that basis. The Supreme Court did not touch that point of the decision. The argument is if the main criterion is primarily created for functional reasons as a functional object, on that basis there is no copyright. Question to be asked then, if we do that in AI, if what I turn out is music to be played in shopping malls to just create an atmosphere, how functional is that? If that is the kind of prompt that you give, I mean, I'm not saying there should not be any copyright in these works at all. I'm simply asking the question, we will eventually have to answer it. What is primarily functional in that context? But if I now turn back to this idea of intellectual creation, free and creative choices, if we try to apply that, for example, first of all, should have put it in a different order, to 3D printing. I think there it's relatively easy. Because if you have, first of all, a drawing, an architectural drawing of what you want to create, clearly that, in that sense, you make choices. If you make them purely for functional reasons, you have a problem. But let's say if you want to create a sculpture-like thing with 3D printing, the argument is clearly you make free and creative choices. It's your own intellectual expression as an author. The fact that you then create the sculpture by using a 3D printer, that doesn't change anything. You know, in the Pioneer case, the camera is also used. Right? We use lots of technology. We use a word processor to type things and so forth. So you go down that path and you say, well, clearly that is still a copyright work. It's an artistic work. Whether we want to consider it a sculpture or something else doesn't matter. Right? That's up to the member states to decide on how they do that, but it's an open-ended system. So that's relatively easy. You just have the pure functionality problem there. If what you generate is really for functional purposes, if the shape is purely functional, then you have a problem in terms of copyright work. It becomes, of course, much more complicated if you decide to move on to AI. Because I personally think, I mean, yet again, let's see what courts eventually decide, or what legislators eventually decide. But I don't think that giving the machine a simple prompt, create me something in the style of Rubens, for example, I don't think that's enough of an original contribution. Because effectively what you do then is you say to AI as the black box in there, you say to the machine, you make the choices. The machine makes them freely. I mean, you and I don't really decide. We have no ability to decide how the machine should make that if we simply put a simple prompt in there. It's the algorithm that will decide how that will work out. As was said in the introduction, it's statistics. The machine will put things together and say, okay, Rubens, what do I have on that? What kind of style was that? What kind of examples do I have? How do I then, on the basis of an algorithm of sorts that's in there, I make something that looks like a Rubens painting? But it's the AI that makes the choices. If you use AI as a mere tool, in other words, if you try to work with extremely elaborate prompts, if you try to dictate yourself more and more what the AI should do, I would suggest that you can make the opposite argument. You can then say there is originality, and it is you as the author. I mean, if you refine the prompt massively and it goes into an awful lot of detail, maybe what you create then is your copyright work, but not the machine's, because the machine is no human author. It's your creativity there. If it's the creativity, well, the word isn't badly chosen, but if it is the algorithm that decides on what comes out, my suggestion is there is no copyright. So in all these novels, in all these drawings and whatever that are simply created on the basis of a simple prompt, I don't think there is any copyright. There is no protection there. That's one side of things, and in the interest of time, I need to move on a bit, because let's also look, I mean, till now we have merely discussed what kind of work can be protected. What is the author's position in there? Well, on the assumption that you have copyright, how is it infringed? Because again, in terms of AI, you get rather interesting things. I mean, okay, if you 3D generate a sculpture, it's the same thing. We know how that works if you make a copy that infringes. AI again makes it a lot more sophisticated, because I come to the Mio case. I mentioned Mio before briefly on the screen. But Mio is a very recent case of the Court of Justice of the European Union, and that is about applied art. Now, okay, first of all, the court says it doesn't matter for copyright purposes. The fact that you can have also a design right in there, that doesn't change anything. You just apply the same criterion in as other copyright works. So the same InfoPack Pioneer logic applies. But it becomes interesting because there's a huge debate going on, and I think a couple of my colleagues, maybe deliberately, but I mean, try to misunderstand or misrepresent things. What the court they say the court's contradicting each other. I don't think it is, because when the court talks about the recognizable copying of creative elements, it's not in the sense of originality. It's in the sense of infringement. In order for there to be an infringement, there need to be a recognizable copying of creative elements. Mio was about tables, furniture. Well, in the alleged copy, there need to be creative elements based on free choices of the designer that you can recognize. If it is no longer recognizable, you may have been inspired by, you may have done something in the style of, but if the average consumer, the average person dealing with these works, buying these works, cannot recognize the elements that you copied, well, then the argument is there is no infringement. strikes me that that is probably in AI an interesting thing, because one thing is all these AI generated works may not attract copyright. Question is, if you are the right holder and you think it's very similar to your work, is there an infringement of your work? Well, the answer may have to be that there has to be recognizable copying of your contribution. In other words, if the AI makes something in the same style, but you can't pick out anything that's really copied, I mean, if I say Rubens and I see bits of different Rubens paintings, that's recognizable. If I see something in the same style, but there is no recognizable element, or if I think, okay, this is something that I could have written, but it's not copying, not recognizable elements, then you have a problem as a right holder in an existing work that you've written yourself, or in a painting that you made yourself, photographs that you've taken yourself. There is, of course, also an interesting aspect that's the output of the AI. That's, of course, also the training of the AI, where AI assimilates an awful lot of information, an awful lot of data, potentially. Now, there is an interesting question there. Let's not go there, because that's a completely different story. The AI people would say they don't make copies of all these works. They just put it in as data. Whether that's correct or not, I mean, personally, I have my doubts. I think you start by making a copy, you make a reproduction, and then the machine turns that into data. But you have made the copy. Anyway, that's a separate debate. Let's not go there, because it will take us the whole evening. The interesting question is, where does the reproduction, if there is a reproduction, as I think there is, if there is a reproduction in all these uploadings, in all this training, where does it take place? Because the AI people the AI companies will try and locate themselves in a place where copyright laws are rather flexible for them. Let me bluntly say, for example, in the United States, where you can argue it's fair dealing. You're covered. You can do what you like. I mean, I exaggerate, right? There's a lot of detail to be filled in there. But, I mean, that's at least what they try and do. There is a case in Munich where the argument is that you could recognize bits of the songs. The German court says, well, that happens in Germany. And they apply German law. It's not the best decision in that sense. It's two tiny paragraphs. There's not a lot of reasoning. Yeah, for a simple reason. In that particular case, the AI people admitted that on their servers in Germany, there was a copy of the software. So it's relatively easy to say, well, we don't have to answer this question in detail, because you yourself admit that there is a full copy of the software in Germany. Well, then it happens in Germany, and we're covered, right? We don't really have to go very far. In most cases, the AI people will say, well, we ourselves have no idea. It goes in a system service left, right, and center. Where does it happen? If we have to give an answer, probably in the United States, where we have fair dealing exception. Now, that I think is where private international law may help us. There's an interesting study by my French colleagues, Tristan Nazy and Dr. El Hay, where they argue, I think in a very convincing way, that we should not let ourselves be misled here by copyright and its territoriality principle, its country by country approach. Effectively, whenever you and I consult AI, whenever we put a prompt in and something comes out, the prompt goes into the system consults all the data it has, and it then puts something back to us. It is an output. Arguably, therefore, it's a whole chain, and for private international law purposes, you should take that chain into account. That's the act that leads to the infringement. Well, that act then takes place, arguably, but I think convincingly, where you put the prompt in. If you don't put the prompt in, the AI system doesn't turn, and there is no interaction with all these protected works. I mean, if in the German music case, the German collective management organization GEMA hadn't asked, if they hadn't asked for, can you reproduce that song, they would never have got the copy. So the argument is, by putting in the prompt, you generate the copy. That's the infringement. Okay, that happens. You can locate that in the country where you put the prompt in. That is interesting because it allows right holders, it allows artists who think their work is being used for these purposes, it allows them to go to their home court or to the court wherever the prompt is being put in, and at least that solves an potentially endless debate where they have to demonstrate where the training took place and where the machine assimilated all that, which if you ask us, how are we going to find out where ChatGPT and other models do their training and uploading? That's not information that is readily available, and we can still bring the claim here. Maybe very briefly, it was also mentioned in the very kind introduction you gave for me. There is interesting work to be done also, very valuable for artists. The European legislation has an opt-out clause. You can opt out. You can say that my work should not be used for training purposes. Again, enforcing it, there is a voluntary policy being put in place, and some major players sign up to it, others are reluctant to sign up, but that's work in progress. At least as an artist, you have the option to say publicly, I opt out. Now, the problem with that is you should do that in any way that is clear. Potentially metadata, that's easier for machines to scrape all the information. But still, if you have to cover all the potential copies of your work that are digitally available, that's hard work. So that's why with Capgemini, we proposed, the European Commission asked us to look at a potential system where there could be a central model, a central database, central point where people could opt out. That should then be working with nodes, and it's not that we're going to put everything, or that the Commission wants to put everything, say, at the European Intellectual Property Office in Alicante. There could be collective management organizations involved. There could be other countries that sign up. It doesn't have to be a strictly European Union, but it would all be interlinked so that for the artist, for the copyright holder who doesn't want their work to be used, there would be the option to register the opt-out once, and you would then expect all the AI people to use that central database, because now they can still hide in saying, how can we figure out that there is, on one copy there is an opt-out, on the other copy there isn't? Well, if there is one central database, they can no longer say that they're in good faith if they fail to consult that database, right? That's the argument. We'll see where the Commission goes with that. Needless to say, there is going to be a need for a lot of political goodwill and political will to get this organized and get this through. The AI people are not necessarily the greatest proponents. And I should say also, much to my regret, I see some people in collective management also hesitate because they want to do their own thing. Well, yes, but if you do it sector by sector only, you cannot replicate one central database. It will never be as effective. I'm definitely running out of time now. I should be very quick. I promised to say something about non-fungible tokens as another thing. Look, we're now in the exploitation, I think, of works of art, because I think again the potential misunderstanding is, well, the work of art remains fungible. You don't create a new work of art for copyright purposes. What you create as the non-fungible bit is the digital file. The digital file that encapsulates the work of art, and that then is being minted, and that goes onto a blockchain. It makes it recognizable. It's tradable. You can sell it as a unique copy on that basis. It's basically you sell on like the painting, right? That's important because the artist retains the copyright. The person who gets the non-fungible token, it's like you acquire a painting, you don't become the copyright owner. You have a right to put the painting on your wall, you can show the non-fungible token. And of course, in a digital world, if you have a digital file on your computer, yes, you must have, implicitly at least in the contract, a right to display it. Otherwise, you have nothing. The fact that it sits on your hard drive doesn't mean anything. You have to display it. That brings me to the final slide. If I come back to my title, Art, Copyright, and New Technologies, an Unholy Alliance? Well, yes and no. I think that there is a lot to be said that a proper understanding of how copyright works solves a lot of problems, and a lot of the vague statements that come from the technology people can be rebutted if you properly understand how it works. On the other hand, how we deal with AI and all this, well, yeah, that's work in progress because the technology is changing and we are only starting to find out what the machine can do and what the human contribution in all that is. So I think that's very much work in progress. Thank you very much for your attention.
Now, according to our general policy, we do continue with the next speaker, and at the end there will be questions addressed to both. So now I would like to invite Dr. Gabor Soós. He's an innovation strategic advisor, Ministry of Culture and Innovation of Hungary, cultural diplomat and university lecturer, former Secretary General of the Hungarian National Commission for UNESCO. So his topic is Protected Works, Unprotected Meaning, Art, AI, and the Limits of Copyright. Bartók's Source Ethics in the Age of AI. So, Dr. Soós, please start your talk.
Thank you very much, dear Johannes, Mr. Vice President. Thank you very much for the invitation. Do you see my slides? Can you just give me?
Yes, we see a beautiful
okay.
folded.
I go to the title page. Okay. This is it. You should see. Okay, yes. That's it. There it is. Okay. Thank you very much. I really welcome this opportunity, and also having heard the introduction of President Mainzer about the role of EASA, European Academy of Arts and Sciences. Bridging arts and science is indeed an issue today, and I think our topic is very pertinent to that mission. So I thank very much Professor Torremans, who has just offered us a clear map of the legal terrain, protected works, originality, authorship, infringement, exploitation, and the challenges posed by AI, 3D printing, and NFTs. This legal terrain matters greatly. Copyright remains one of the central instruments through which modern societies protect works, authorship, and important economic interest. In that sense, I begin from agreement, not disagreement. And I hope I can move. Yes.
Dr. Soós, can you please make your picture bigger?
It is.
It is the best you can do. We also see it in small version on the right, but yeah, if possible.
I have put it on the large screen.
Okay,
maybe
if that's
this way.
The best you can do. Yes, okay, it's readable. It's fine.
Okay. Sorry, I think I moved one ahead. Up. Here you go. So, but my question begins today where the indispensable legal framework starts to reveal its limits, and Professor Torremans already pointed to that. Because in the age of generative AI, not everything that matters culturally appears in the form of a clearly protected work. And not every cultural loss takes the form of recognizable copying. We are increasingly confronted with forms of value that are harder to isolate juridically, yet are no less real for that reason. Style, contextual meaning, cultural memory, communal significance, and the integrity of interpretive environments. These are not marginal matters to my mind. They belong to the very conditions under which our culture and arts is lived, transmitted, interpreted, and renewed. So my argument today is this, very simply. Copyright remains necessary, but it is no longer sufficient on its own, on its current terms. This is not because copyright has failed. It is because the technological environment has changed. Generative AI systems do not merely reproduce or distribute artistic and cultural materials. They increasingly participate in its production, transformation, circulation, and the mediation of very meaning itself. They affect not only works, but the environments within which works are encountered, understood, recomposed, and valued. And once this happens, the question is no longer only legal. It becomes at the same time cultural, hermeneutic, and normative. Let me start with what copyright does well and why it still matters. Copyright protects identifiable works. As Professor Torremans just shown, it protects authorship, it protects certain economic rights. It preserves at least part of the link between creative labor, selection, and legal recognition. It can still function as one of the last legal bulwarks against the total dissolution of artistic creation into a mineable reservoir of patterns. In a world where AI systems are trained on and operate through immense bodies of cultural material, that function still remains essential. This is especially important because AI blurs the distinction on which older legal frameworks depended, the distinction between original work and its derivative use, between creation and reproduction, between inspiration and extraction, between tool and authorial agency. In that sense, copyright remains indispensable precisely because the line between creation and reuse is becoming harder to see. For the legal framework remains structurally stronger in relation to what can be identified as a work than in relation to what culture often experiences as its deeper substance. A style, for example, may be central to an artistic tradition without being straightforwardly protected as such. A local narrative may carry dense communal meanings without fitting neatly into standard categories of individual authorship. A ritual, a place-based interpretation, a curatorial environment, be it a museum, or a historically sedimented mode of seeing may matter immensely without appearing as a clearly appropriable object for copyright. And that is the first difficulty. The second is this. What culture loses under AI conditions may not appear as an act of obvious copying at all. It may appear instead as flattening, as decontextualization, as stylistic dilution, as the quiet replacement of the interpretative struggle by an algorithmic fluency, as the transformation of a tradition into searchable fragments or of a place into a set of usable motifs. What the law may not always recognize as infringement, culture may still experience as erosion. This is the gap in my title, Protected Works, Unprotected Meaning. It points precisely to that gap. Let me put it even more sharply, perhaps. Law may ask whether a protected expression has been copied. Culture must also ask whether meaning has been thinned out, whether context has been detached from the source, whether symbolic density has been reduced to usable surface, whether the relation to tradition has become merely extractive. And once we formulate the question this way, we need a wider vocabulary than copyright alone can offer. Almost a century ago, Walter Benjamin argued in his famous essay, The Work of Art in the Age of Mechanical Reproduction, that modern technologies of reproduction were transforming the status of artwork itself. When a work can be endlessly reproduced and detached from its original time, place, setting, something of its singular presence is weakened. Benjamin called this aura, or aura, the unique here and now of the work, its irreducible situatedness, its authority as something encountered in its singular existence rather than endlessly duplicated. What mattered in Benjamin's argument was not only that copies multiply, it was that reproduction that changes the mode of presence of the work. The artwork no longer appears only in its singular place, ritual setting, and material uniqueness. It becomes portable, repeatable, detachable, transferable across contexts. Actually, that was Plato's concern as well about writing, as Derrida recalled it. In that shift, something happens to authenticity, authority, and the experience of encounter itself. Benjamin's question was therefore never just technical. It was already a question about mediation, historical presence, and the altered conditions of perception. Now, Benjamin still gives us a powerful conceptual bridge, but our question today is no longer only his question, only Benjamin's question, because AI and digital systems do more than merely reproduce. They recontextualize, they tokenize, they reconstruct, and they simulate authenticity. They redistribute authority. They generate derivatives that may appear new by drawing their symbolic force from prior cultural forms. They can surround the copy, the token, the reconstruction, or the AI-generated derivative with a newly manufactured aura of uniqueness, novelty, scarcity, immediacy, or even technological prestige. So the issue today is not only the loss of aura, but also its technologization, if that word can be used. In some cases, we have moved from the fading of aura to its digital fabrication. The problem is no longer only that uniqueness is weakened, it is also that new forms of symbolic charge are artificially produced around the surrogate, the token, the reconstruction, or the generated image. The issue then is no longer only ownership of the work, but the governance of its digital afterlife and of its making as well. This matters especially in relation to NFTs, 3Ds, AI-generated visual derivatives, and platform-mediated circulation. In each case, the question is not simply whether something has been copied, but how authority, how authenticity, and how perceived value are being rearranged. What exactly is being authenticated? The original, the token, the file, the experience, the trace of the source, or merely a technologically enhanced claim to attention. If Benjamin helps us diagnose what reproduction and now digital remediation does to the status of the work, Béla Bartók helps us ask a different question. How should we relate to the source before reproduction, before recomposition, or before transformation begin? This is where I would like to bring in Béla Bartók. He matters here not simply as a composer, as an ethnomusicologist of the last century, nor only as a figure of Hungarian cultural memory, but as a methodological and ethical guide. His famous principle, often rendered as only from a pure source, should not be misunderstood as nostalgia, nor as the rejection of mediation, nor certainly as rejection of technology. Bartók used the high-tech technology of his time. The phonograph was, in a very real sense, one of the advanced media technologies of his age, in the 20s and 30s. What mattered to him was not the rejection of mediation, but the sequencing and the order of mediation. First, presence, field presence. First, listening to the folk songs in the Transylvanian villages. First, encounters with the original performers. First, the village, the singer, the context, the lived form. Only then recording, comparison, classification, transformation, and recomposition. This is what I would call Bartók's source ethics. Its significance today lies not in literal imitation, but in the normative order and the ethos it proposes. Before extraction, listening. Before modeling, encounter. Before recomposition, understanding. Before system, the source. In that sense, Bartók offers us not a legal doctrine, but a discipline of sequence and ethos. And this is the sequence that is highly relevant in the age of AI. Because what many AI systems do by default is to reverse this order. Extraction comes before understanding. Pattern comes before presence. Recombination comes before responsibility. The material becomes available first, and only later, if at all, do we ask about context, community, or its original meaning. We move very quickly from access to transformation, from ingestion to output, from source to system. But the fact that something can be processed does not yet tell us how it ought to be approached. This is where the difference between legal availability and cultural legitimacy becomes decisive. Platforms can now extract culturally dense materials, folk songs, motifs, costume forms, paintings, novels, you name it, even traditional knowledge, and convert them into reusable pattern material. Others may then draw on the outputs at several removes from the source itself. What is preserved, at least superficially, may be the form, but what is often weakened in the process is context, the chain of transmission, the relationship to place, the communal world of meaning, the discipline of interpretation. This is why the problem is not only copying, it is also flattening, not only reuse, but decontextualization, not only access, but extraction. We have seen earlier versions of this problem before. Think of El Condor Pasa, and now you think of Simon and Garfunkel, or you think of the Andean folk song. What entered global circulation sounded to many listeners like anonymous folk material simply available for reuse. But the history was more layered than that, involving composition, tradition, mediation, and misunderstanding actually about the source. Even Simon and Garfunkel said that they misunderstood. The legal dispute matters, of course, but so does the deeper lesson. Source is not always exhausted by the categories through which it later circulates. The deeper lesson concerns the relation to the source. Something may be legally accessible, yet culturally mishandled. Something may be usable within a narrow doctrinal frame, and yet still represent a diminished, distorted, or extractive relation to a source. This is particularly visible in the arts, in heritage, and knowledge institutions, because here source is rarely just origin in a technical sense. Source is also relation. Source carries context, transmission, responsibility, asymmetry, and often memory. A source is not simply something one takes from. It is something one enters into relation with, like tradition and individual talent in T.S. Eliot's essay. This becomes even clearer in the case of living cultural traditions. Much of what matters may lie not only in a discrete work, but in communal significance, in transmission, gesture, performance, context, voice, rhythm, memory, or relation. Once again, law is not irrelevant, but law alone does not exhaust the field. In such cases, contemporary ordinary copyright categories are often too narrow. What is needed is a broader ethics of authorization and stewardship, something closer, in my own terms, to an upgrade of the current FPIC principle, the free prior informed consent principle, into something like a fair share and digital cultural sovereignty, FSDCS, if you want. Not only permission in a formal sense, but meaningful accountability to source communities in how cultural material is assessed, transformed, and recirculated. Fair share, digital cultural sovereignty. This is why I think contemporary debates at the intersection of art, AI, and copyright should be situated within this broader inquiry into legitimacy, responsibility, and cultural governance. The question is no longer what current law permits. The question is also what kind of human-machine relation to art and cultural source material we should consider legitimate. And let me bring in a contemporary example. Consider the work of Ting Song on the left or on the right of the slide, a young Chinese AI and blockchain artist whose practice moves across generative jewelry, NFT-based digital works, AI films, skiffies, and reinterpretations of classical and traditional cultural material from Dunhuang-inspired imagery and Zhuangzi to Mudan Ting, that is the Peony Pavilion, and textile traditions. Here you see Siddhartha from a Buddhist tradition. This is genuinely interesting work. It shows that AI is not simply hostile to tradition. It can also become a medium through which inherited forms are re-entered, reimagined, and recirculated. So I'm not by definition against AI art. I just want to see how it happens, because it also happens, our question. Legally, we may ask about authorship, originality, derivative use, and the status of the source material. Yet culturally, another question appears immediately. Does technology deepen the relation to source, or does it mainly repackage source into novelty, circulation, and symbolic prestige? That may also be a legitimate aim. The value of the example lies precisely in the fact that it does not yield a simple answer. It shows that the real issue is not technology versus tradition, but the quality of mediation between them, how this happens. So, this is why Bartók remains, I think, very helpful. He reminds us that mediation is never innocent. The order matters, the ethos matters, the relation to the source matters. The question is not technology as such, but the quality of mediation. At this point, let me identify more precisely what does not fully capture, what AI makes impossible to ignore. First, style. Style is not simply a decoration. It is often the trace of formation, tradition, discipline, and artistic density. Yet style is difficult to protect straightforwardly as such. Second, contextual meaning. Cultural materials do not live in isolation. Their significance depends on relation to their time, to their place, to the institutions in which they are created, to memory, and to their audiences. AI systems often extract at scale from the contexts and they do not preserve them. Third, communal significance. A culture of form may matter deeply to a community without fitting neatly into the model of individual authorship on which much copyright law depends. Fourth and last, interpretive environment. This is perhaps the most overlooked category. AI does not only produce outputs, it reshapes the background conditions under which interpretation happens. It changes expectations, it changes speed and scale. It changes what feels plausible, sufficient, or complete. And here we come to a deeper anthropological point. The challenge of AI in culture is not only that AI systems generate new images, texts, or aesthetic combinations. Fair enough. It is also that they risk displacing the slow inner work of interpretation. If everything arrives already smoothed, already summarized, already recombined into fluent plausibility, then the human effort of attention, of hesitation, of individual judgment, and contextual understanding begins quietly to erode. This is why the issue is not merely one of excess. Excess without interpretation is not yet understanding. Convenience without resistance is not yet culture. This is what I think the future of art and AI cannot be framed only as a question of ownership, infringement, or exploitation. It must also be framed as a question of stewardship. Stewardship means that cultural material is not treated merely as raw input or monetizable output, but as something entrusted to institutions, communities, creators, and various publics under conditions of responsibility. Stewardship asks not only who may use, but how one ought to receive, transform, and pass on. It is a vocabulary that law alone cannot provide fully, but which law may need to be complemented by. In this sense, cultural governance becomes essential. If the legal framework cannot by itself bear the whole burden, then museums, archives, universities, heritage institutions, and institutions like the European Academy of Arts and Sciences, and cultural policy must become more active in defining the terms of legitimacy. Here, ideas such as provenance, consent, contextual integrity, and traceability become important, not because they replace copyright, but because they help address what copyright leaves less visible. And this is also why I believe cultural institutions matter so much in the AI age. They are not merely repositories of content. Imagine a museum. A museum is a credible place. A museum is a curator of reliability. A museum preserves context. It maintains distinctions. They help hold together meaning against flattening. In an AI-saturated environment, this role may become more important and not less. And now, if I may, I would like to end by opening the argument slightly beyond copyright. 3 short images, metaphors will help, and we are near the conclusion. So, first, culture must remain a compass. Law alone cannot provide orientation. It can protect, prohibit, allocate, and recognize, but it cannot by itself tell us what kind of cultural futures we are making more likely. Culture must therefore remain a compass, helping us distinguish enrichment from diminishment, interpretation from simplification, and responsibility from drift. As I have argued in another context, culture cannot remain only an external ethical reference point for AI. It must also help shape how AI is oriented from within. Second, AI should function as a prothesis, not as a surrogate. A good prothesis extends human capability without displacing human purpose. I can have a prothesis left foot, but my prothesis should not tell me where to go. I decide where to go. In the arts and in the cultural interpretation, AI may assist, expand, connect, and support. But when it begins to replace judgment, interpretation, and inward formation, it becomes not an aid, but a substitute. And the substitute, however efficient, however smart, may erode exactly the very human capacities culture is meant to preserve and to cultivate. The distinction, as I have put it, is between prosthetic enhancement and cognitive or cultural crutch. Third and last, AI should become a bridge and not a shortcut. A bridge connects lived encounter and digital mediation without collapsing the interval between them. A shortcut bypasses that interval. Bartók's source ethics, I believe, teaches us how to think this bridge well. First the source, then the system. First the encounter, then abstraction. First understanding, then recomposition. In this sense, AI should not automatically be assumed to function as a bridge. It must be shaped into one. So let me conclude with the simplest possible formulation. Protected works remain essential. Copyright remains indispensable. But in the age of artificial intelligence, we must also learn how to protect what is not fully captured by protected expression alone. Unprotected meaning, contextual integrity, communal significance, and the conditions under which culture remains humanly inhabitable. So the deeper question is no longer only what machines can do with art. It is what kind of human relation to art, source, and meaning can we choose to preserve as these systems become more and more powerful and pervasive. And that, I believe, is where Bartók Béla still speaks to us most clearly. I thank you very much for your attention.
Very, very interesting. I would like to invite members of the audience to ask a question to any one of the two speakers.
I have a question, Professor Buntis.
Yes, go ahead.
Can you hear me?
Yes.
First of all, I would like to thank both speakers for the very interesting and rich in knowledge talks. The question, I have really two questions. The first question is, here in Geneva, we have an organization which is called WIPO in English, which means World Intellectual Property Organization. And my first question is, can we say that property and copyright is the same or is completely different?
You really want a short answer to that. I think the clear argument that has been made is that copyright and other forms of intellectual property are very close. The way to protect the work, the way to protect the invention, the way to protect a certain aspect of the culture is by giving it a property style right. That's also what you find in the European Declaration of Fundamental Rights, Article 17, paragraph 2 says intellectual property is a form of property, it's protected in the same way. Of course, there are nuances. Now, what you see is that the treaties that WIPO administers mainly create property rights. The mechanism to give control to artists is by saying you have a property right that you can then license, assign, waive, whatever you want to do with it. Moral right, for example, in copyright, I personally wouldn't like to call that property. My right to integrity, my right to paternity, that's not a property style right, but the mechanisms that are being used are property style rights. You find also an increasing emphasis on limitations and exceptions. And again, that is to limit the scope of the property right. I mean, think of extended rights for the blind and visually impaired, to make reproductions, to have versions of the work that they can read, they can access. That again is yes, an exception to property if you want, but I think it goes beyond that. But WIPO's work is mainly based on property. But what's in a title?
So, if I understood well, if we take the case of the marbles of the Parthenon, can we say that it is the property of the Greek nation or the Greek people?
The blunt answer, I think, is no. The blunt answer is that, I mean, look, there's a lot of fog in history, right? But the argument is that in terms of property, they were, for a symbolic price, sold at some stage to a gentleman who took them to Scotland. And later they ended up in the British Museum. The question then, and I think that's where our two presentations fit together, the question is, that's not the whole story. There is also, if you want, a property. I don't like to call that property, but I think it's part of Greek cultural entity, identity, and in the context of where these works belong, well, that context is, as far as I can see, 100% located in a territory that is now called Greece, right? I mean, it was larger at that time when this was created. Parts of Turkey were also part of that cultural environment, and so forth. But that's where they belong, right? In terms of pure property, I think there is an issue. There's an argument for saying there was a commercial transaction all these years ago, and that's how they now belong, owned by the British Museum. But I think we demonstrated this evening that that's not the whole story.
Okay, thank you very much.
Miss Mila Popovic.
Oh, very good. Thank you so much, and thank you for having me in this wonderful forum. I have to thank the European Academy and both of the professors, because Professor Torremans laid the normative foundation without which we wouldn't be able to stand argumentatively. And then Professor Soós just really zoomed out on the cultural dimension that is meaning making and symbolic making, symbol making capacity of the humans. I forgot to introduce myself. I'm Mila Popovic, and I'm a fellow and trustee of the World Academy of Art and Science, and also a founding director general of interculturalism in the government of Montenegro. Why that matters? Because my directorate is in the Ministry of Human and Minority Rights. So legitimizing my input here, if you will. I'm really, really grateful on how this was built as an argument, as well as the way the two presentations got us to a threshold of which I frequently speak in other forums, where we understand the quality of human decision depends on the quality of the questions that we ask. And we know that now, both as philosophers of technology and philosophers of society and culture, as well as, say, GTP or Claude users, what you get out of it in terms of output is essentially dependent on the quality of questions that you ask. And that's where the beauty and the danger equally is. So I would like to use this moment to, in the spirit of collective intelligence, to reflect quickly with you on the moment in which we find ourselves, that the emergence of artificial intelligence, which is the harvesting of civilizational accomplishments and collective intelligence, took us to the place where we have to see ourselves in the mirror and ask these much larger questions of what constitutes humanity, human experience, human expression. So we are, allow me to reflect with you quickly and ask hopefully qualitative questions here. We're entering obviously a profound civilizational transition in which AI is and emerging technologies are not only transforming what we do, but as Professor Soós was pointing out, rightfully so, they're reshaping how we perceive, interpret, and experience reality itself. So in this evolving landscape, intelligent and increasingly now agentic systems mediate perception and attention, identity, and self-representation. As we said, cultural production and the very conditions of visibility and meaning. So, while the current debates typically focus on and necessarily focus on authorship, copyright, and ownership of creative outputs, a deeper and more urgent question emerges, that is who and what governs human agency in the AI era. So that the shift requires an expansion of governance, as Professor Soós was pointing out, from regulating technological outputs to addressing the very conditions of human perception, agency, and human experience itself. So the key questions, besides of who and what governs human agency, is also where do we see that humans are losing orientation faster than gaining capabilities with AI. And also, as we have, I feel, already collectively asked, the question is then, which decisions have to remain irreducibly human, and why? So to round off this reflection with you, I have, just like Professor Soós, saw the need for expanding the normative framework unavoidably, and have been advancing the concept of aesthetic rights, developed as the part of an ongoing body of work at the intersection of human rights, technological transformation, and global governance, as the protection of the integrity of human perception, subjectivity, self-representation, experiential reality in the mediated environment. So thank you for giving me the space to put this forth with you, and to also point out that we have known that at the core of the political representation, the aesthetic has always been there. So I'm very grateful that Benjamin was invoked, and Bela Bartók, of course. And most importantly, based on what I just said about reality, human perception, and who becomes visible and how they're visible, who's harvested and who's capitalizing on the human knowledge that is being harvested, the question remains, who are the communities, people, regions, systems of knowledge that only exist in aesthetic states without political representation? And what kind of new process of social learning are we going to have to develop to meet ourselves at this limit and see ourselves in the mirror in terms of, my ultimate question would be, how do you design a beautiful mind reflective of humanity? And that will require an ethical, aesthetic, and ecological code. So thank you so much because it's obvious that you got me really inspired so that I can share with you a piece of my reflection here.
Thank you. Thank you very much. Klaus, did you want to add something?
Yeah, I have a short question to both speakers, the same question. From the point of view of European Academy, that means different countries. And in different countries, even in the democratic tradition, there are different legal systems. Roughly speaking, there are two types. On the one side, the continental type, especially Germany, it's very dogmatic. That means, like in mathematics, there are axioms. These are the constitutional laws, human rights, and so on. And then the special fields of law are deduced. And if you, as a judge, have to make a decision, then you have to relate, like in a deductive system in mathematics, to these derived propositions. Now, quite different in the US tradition, for example. If you have to found a decision, then you have to relate to a former decision as another court. For example, in Chicago in 1900 and so on, there was this and that decision in that field, and in Detroit and so on. So it is a more inductive style, coming up from case studies, case-oriented, deductive, dogmatic. Now, my question is, does that matter for copyright? Because the copyright question in art, for example, is international, of course. And is there something like in law we say comparative law, comparing the different legal systems, also in other fields of law, now here in the copyright and intellectual property field. By the way, what in the second talk was mentioned, the value questions in the background, they are also different. In the continental style, the more deontic style, and in the other fields, the more utilitarian style, which is related to that. But my question is to the practical aspect, namely copyright in these different legal systems. Thank you.
Well, as a lawyer, should I maybe go first and try and make a start, and then Dr. Soos can elaborate on the other aspects. I think from a dogmatic point of view, of course, copyright is a territorial right country by country, and we have different traditions. But I think we should not exaggerate. There are quite a number of international instruments in this field. They are the same. There are also in the US, there is a vast number of statutory provisions, also in the United Kingdom. So in a sense, it's not that it's purely based on case law. It's also German courts are quite good in referring to cases and not necessarily only German cases. So there is more harmony than it shows. I must also say, if you follow the pure idea of the flexibility of the common law, then you would find that in AI cases, for example, Anglo-Saxon courts would be much more advanced than German courts. Leading cases for the time being come as much out of Germany as they come out of the United States. So I think it's an interesting mixture. It's also quite interesting to see that in practice, the international copyright community talks to each other. We don't live on our own islands. We have a very lively debate. And in that debate, cases and legislation are being compared. Wherever they come from, it doesn't quite matter that much whether it comes from common law or from civil law, and within civil law from which discussion. There is a clear recognition that this is a global issue, and that this is also an issue, and I think I hand over to Gabor on this one. It's also an issue where other elements, apart from the pure legal copyright issues, come into play. And I think that's where the international community understands each other, where the needs are and where the sensitivities are.
Thank you. Mm-hmm.
So I think it's my turn. Thank you very much for all the questions. I think they are very inspiring to think further what we have said. Let me take follow up on Professor Torremans' point about the legal aspects in which I'm less familiar with, but with the framework I'm most familiar with is the UNESCO framework, since I have been working 25 years in the UNESCO ecosystem. And UNESCO is at a pivotal point. UNESCO adopted in 2005 the Convention for the Protection and Promotion of the Diversity of Cultural Expressions. Before that, it adopted the Intangible Heritage Convention, in which communities, local communities, not necessarily states and nations, communities became the bearers of heritage, right? So not like in the World Heritage, where the state is responsible. The state is also responsible in the 2003 convention, but it's with the community's participation that it can implement the convention. So we have an architecture in which communities have come to the fore in 2003. We have a convention from 2005 about the diversity of cultural expressions. And then in 2001, UNESCO had adopted a recommendation on the ethics of artificial intelligence. And now there is an ongoing discussion and debate about adopting an additional protocol to the 2005 convention, because the context has changed. This is what I was trying to argue about, that the technological situation has massively changed. In 2005, there was what? There was YouTube, there was social media already, but there were no digital twins, no mass scale algorithmic use, etc., etc. So for the convention to retain its normative purpose, we need to adapt. We need to adapt the normative framework, and copyright is certainly one possible angle. But I think if, especially for culture and the arts, I think that this debate about the additional protocol in the digital environment could be a very important point for UNESCO to address. And this is ultimately not UNESCO, but member states, the 184 member states in UNESCO. So the question, I think, was by Professor Mainzer, if there is a comparative field where the different national traditions and continental American traditions can come together. Well, even though the United States will leave UNESCO at the end of this year, so they may not participate in this debate, but very important countries from both the global south and the global north do participate in this debate. The European Commission has taken position as well. So I think that will be a major field where the future of AI in the age of artificial intelligence will be meshed out in legal terms. So that's and I can talk a lot about that. I've just submitted a paper to a magazine, so I'm happy to address that. But on the broader questions that Professor Popovic brought up, what resonated especially with me is her suggestion about aesthetic rights. I would really like to hear more about that. And also the non-correlation between communities and recognized states. So I think that's very pertinent. Think about indigenous communities, think about traditional ethnic minorities. I think that's relevant. That's, I think, part and parcel of cultural rights. But if cultural rights are broadened, then so do aesthetic rights. And the other was the orientation question. I use the metaphor of the compass. That, you know, that I need a compass. So AI use is not only a skill. It is not simply digital literacy skill. It is not simply a skill. It is an orientation. It is an orientation. How we interact with the machine, with the possible cognitive outsourcing of our autonomy. So, you know, there is a generation that is growing up which have not been steeped in analog culture as we have been, that is digital born. And for them, it may be just more handy to accept, but sometimes they are actually more critical. But there is, you know, there is the natural tendency of humans to be lazy and to choose the easy option. So when an algorithmic system gives you an answer to a prompt, you know, if you don't have the time, you just accept it and go with it at face value. But I think there has to be a moment of interiority, a moment of ethical hinge, where this interaction with the machine is slowed down, where cognitive autonomy can take root, where we don't just outsource and use AI as a surrogate for our own intellectual and even aesthetic effort, but make it on our own. I mean, AI can be a Socratic tool as well. There is also talk about Socratic AI. So we can enter into dialogue. So I believe the big challenge is to incorporate our millennial analog cultural practices and adapt it to the algorithmic context. And we need humans who are multi-literate in the sense of being able to move between analog, digital, and algorithmic contexts, back and forth. So to use AI, but then go back to real-world scenario, and then use AI if you want to understand better in something, but don't take it at face value. So this is roughly the direction in which I am thinking about this. And thank you very much for the question.
Do you mind
Thank you
if
very
I
much.
jump in just with one sentence? Because this is really a true dialogic, a co-evolving thinking together.
Yes, go ahead.
You spoke about a paper that I'm actually just also completed. This is the sentence that I want to share. The notion that we have already passed the attention economy and we barely coming to grips with what that is and how to govern it. But we have already moving at what I'm terming qualia economies, where the very subjective experience of reality is being, I'm using here less formally, but harvested. So the risks are significant that the subtle engineering of perception and behavior, the commodification of human experience in this emerging qualia economies, this is where the subjective perception itself becomes a site of extraction, optimization, and value creation. And this could lead to the erosion of agency and identity coherence and algorithmic shaping of social cognition and lived reality. So I'm really excited about the richness of our questioning these questions together.
Thank you. I think we could go on separately.
Well, I
Yes,
think
please, let's connect.
yes. It lasted a little longer than we had expected, but certainly these were very inspiring speakers. And in fact, you also intersected and wove this discussion to make us see also connections between you and what you are saying. They were not parallel talks in my
Assos,
mind.
there is a question in chat
Yes.
by someone.
There
According
is,
Professor Soó's presentation, can you see
let
it?
me see. Uh,
They're just email addresses.
Yes, this one.
According to Professor Soó's presentation, if I understood well, the style of these monuments as an element of the work is protected with copyright law, and furthermore, the monument itself, like the Parthenon marbles, belong to our cultural heritage as a whole work. I don't understand it very well, but I think that's what the speaker actually said.
If it's really my point, I don't think I really said that exactly. I would not say it in that way, but I would agree. Well, there are two things. There is the one very acute legal debate about to whom the Parthenon belongs, that I mean the Elgin marbles belong. And I am aware of that debate, and probably it's not tonight that we will we will find a solution to that. So
Yeah,
I think it's but I think the broader question that was raised was about style. And then we don't have to talk about the Elgin marble, we can talk about any monument. So if tomorrow an architect uses the motifs of the Elgin marbles, I think that's legitimate. I mean, architects have been using past historic monuments always. They have imitated, they have changed it. I think that's fair enough. Now, if you create a database of historic buildings and you build up, you know, I'm just improvising, you build up a stock, like a shutter stock, like of historic buildings, and then you use a chatbot, you build up a chatbot which will design for you buildings on that basis. Now that is an interesting issue, that to whom belongs those works, and not necessarily works of art, but simply works.
Yes, I would like to just to give some, let's say, explanations to my question. According to what was said, the Parthenon, if we admit that it was sold correctly, I don't agree with that, but let us say that it was sold correctly and belongs to Great Britain, then the copyright continues to belong to Greece, which means it is for personal use, like a singer. He has a lot of CD-ROMs that go sell, but for personal use, but he has always the copyright. So in my opinion, the difference in my question, property and copyright, is the same. In my opinion, it is not the same. You can sell the property, but not the copyright. If concerning the Parthenon, I think that nothing was sold, so property and copyright belongs to Greece. Thank you.
Yes, but
somebody else.
Today the AI was the protagonist in our meeting, and if there is another comment to be made, it should include that aspect.
And also to announce that the next meeting, it is on 4th of May. The cultural heritage at risk, the impact of new technologies, with speakers Professor Stone, Tom Levy, and Matthias Stirlitz. And the last one will be 27th of May by Alexander Herman. And that will be the end of our first round of this colloquium.
Very good. Okay, we all thank you very much for your presence and interesting questions and discussions. Yes, it was very enlightening, I think. And we meet again next time, huh? Yes.
Thank you. Yes.
In May.
Yes. Next time, as I said, yes.
So,